Tennessee in this honorable court. Please be seated.
Good morning. Glad everybody, I hope, made it through the storms last night okay. It's been an adventure here in Knoxville, certainly, for the past week. Call the first case, please.
Re Jonah B.
We'll hear from the appellant when you're ready.
Yeah, I'm going to take about 7 or 8 minutes and adjourn my argument from there. One thing I'd like to point out to the court.
How about reserve 5 minutes rebuttal? That's
Yeah,
about the most,
that's fine.
That'd be fine.
Yeah, I'm not got that much to say.
I understand.
I'm Steve Hurst, the Campbell County Bar. I would like to point out to the court that Mr. Basista and I are the dinosaurs in our circuit. We have practiced longer in the circuit than any other lawyers, and we're about 3 or 4 months apart. So we're kind of the old school attorneys, but he and I've been together around for years. And
I understand being a dinosaur about I fit right in there. So
I'd like to clarify one thing. It was in my brief. I conceded at the very beginning of this case that the severe abuse finding was clear, convincing basis for a termination. The brief is supposedly supposed to, as the argument does, on the focus of the second prong, which is that the preponderance of evidence doesn't support the best interest of the child being terminated. And that is the sole. I want to clarify that was unclear from my brief, and I apologize for that. I just simply want to say that the judge enumerated 7 or 8, I think there were 8 bases, and we do not think that the record supports that. Generally speaking, the state of Tennessee, through the Department of Children's Services and the probation department, set out a set of rules and guidelines, and my client complied with those. And as the probation officer testified, when he had those issues, the records of the classes he attended and such items, he complied with those rules. The only one that was most prejudiced by is, and partially because of COVID, is the parental contact or bonding with the child, given the fact he had only 2 hours a week. And I think the system penalized him, and when COVID came, that became a Zoom and not even in person. That's the most telling argument in the 8 bases. But as you look at the record, they don't support the findings. He availed himself to the programs that were available. He worked. He paid child support. He visited with the child. There's some allegations of a unhealthy home, but there's no record in it whatsoever. There were questions raised about the ability to treat with medical issues, and the only thing in the record reflects that he had went to doctor's appointments, had been involved in it until he was cut off again by the system. I would argue that the system is designed for the road back for a parent, and when you comply with the dictates of the system, both in the Department of Children's Services and with the probation department, that you're then penalized by the same system when you do what you're supposed to. We feel like that the record, in essence, doesn't support the findings of the court, and the fact the record tends to support that the best interests of the child are not served by the terminating of this father's rights. And for those reasons, we think the court erred, and the matter should be set back and either dismissed, and frankly go back to the juvenile court and do a return of home as provided in that system.
Counsel, let me ask you a question, please.
Yes,
Why was the father only allowed limited visitation in this matter?
I'll be very honest with you, to be very candid with you. He had appointed counsel, and I don't think the lawyer fought hard enough. That wasn't part of my time. And we had a very restrictive judge, Ms. Sammons, who tended to be very harsh in these situations, and frequently those visitations are patterned after the Department of Children's Services having only 2 hours a week that they would allow, and I think she followed that pattern in a situation where she didn't have to. I wasn't involved in that, but I think I would have fought long and hard on that one.
Does the record reveal any reason for that? I understand that's your belief and very well could be accurate, but there's no reasoning in the record for the limited visitation?
No, sir. And I'll be candid with the court, I took this case after those facts, but I glanced back through it, and it just seemed to be that's what they were going to do. My guess is, and it's a guess, is that she followed the Department of Children's Services guidelines when they supervise, and that's 2 hours a week. You hit that hammer, and you literally, when I've had these cases in juvenile court, you have to fight for more, and apparently this wasn't done. But he did do it, and he went to during the time until the COVID and all that came along, he did go to doctor's appointments, he did exercise at 2 hours a week, and he did it through this whole process until this order went down. He did everything they let him do, and I think that shows his effort in trying to establish a relationship with his child. I agree with the court. I think it's unfortunate, but there's nothing to show why they did that other than they did.
Was there ever a request made to increase the visitation?
Before my time on that, but not that I could find. We've got a system where we have a lot of young lawyers, frankly, who do a lot of appointed work in juvenile court, and the lack of experience there is overwhelming at times, and they don't maybe advocate as strongly as experience would allow them to. And I'll be very candid with the court on this. Had I had the severe abuse finding, I would have appealed that court in circuit court. I mean, I felt like that was an absolute case that should have been done. I got to live with the results. I didn't do that. And I did talk with the counsel about it, and he admitted to me that he did not appeal that. And I think, that was devastating in this case, and in terms of the first prong. But I wasn't there, but my review of the record doesn't support anything that you've asked.
And DHS
I'm sorry?
DHS was initially involved in this, or DCS
Absolutely.
was initially involved in this. But
Yeah, and he did all the programs. He even went to the stage of doing volunteer work for drug treatment, outpatient. He would go to the jail and talk to people and get them into treatment. I mean, he took stuff he didn't have to do, like parenting classes. He took them twice. He did everything in trying to reach back. Has he made mistakes? Yes. Are they in the record? No question about it. But, at some point in time, the rehabilitation's got to mean something.
thank you.
No.
Thank you. You have your time for rebuttal. We'll hear from the appellee.
Good morning, everyone.
Morning.
I think I have an idea of why his visitation was limited. First of all, we've got to remember that juvenile hearing, the final adjudication, took place before Mr. Huckabee started on the path of trying to rehabilitate himself. And what the facts were at the time of that hearing was Mr. Huckabee had a 14-year history of drug abuse and addiction. He had records before the court that he had physically abused the mother of this child with whom he was living. He served 2 jail terms over breaches of that order of protection. One a 91-day sentence, I believe, and another a 60-day sentence. There was testimony before the circuit court of a witness that watched him beat the biological mother while they were in a car. And in fact, the witness's husband had to pull him out of the car to get him to stop. So he had a history of physical abuse, stalking, and drug addiction. And in fact, as much as I congratulate Mr. Huckabee for his attempt to rehabilitate himself, and he's been successful now for about 1.5 years or 2 years, But we all know that that's going to be a lifelong struggle to stay sober and clean. Now, he admitted that while the mother of this child was pregnant with this baby, they both used methamphetamines. And this child was born with tested positive for prescription medications for marijuana and methamphetamines. In fact, the child was born 3 months premature and stayed in the NIC unit for 3 months and still has medical problems. The child weighed, I think, 2 or 2.5 pounds when he was born. So the history of abuse and drug abuse is why the juvenile judge didn't permit him more visitation than that. And he never did appeal that judgment. He never did seek more time with the child. Now, as far as this termination and adoption case, I cited a case of Re Markham. It's a September 22 Supreme Court decision out of Davidson County, and I frankly don't think I recall seeing a case that's more thorough on discussing termination and adoption. That case had everything in it. The first thing I think I want to say about that is that court points out that in Tennessee, whereas it used to be the purpose of juvenile court was to reunify the parents with the child, that has changed. The primary purpose now is to find a good, stable home for the child. The court looks at both options, but the old option of reunification isn't the prime focus now. And there was no reunification in this situation. The court also points out that the findings of fact, which the judge in the circuit court makes, are by a preponderance of evidence. And it's only when you look at all of those findings of facts together that the court has to look at the clear and convincing evidence standard. So now, Judge McAfee, to his credit, went through 22 pages. You can count the pages. He had 22 pages of findings of fact and conclusions of law, which thoroughly addressed what was in the transcript and which thoroughly addressed what was testified in court. I don't think I've ever seen a more thorough dissertation on findings of fact and conclusions of law. And I've seen a lot of them because these emails we get every day with all these cases in it, I counted one time, and there's 40% of those cases were termination cases. There are tons of those cases out there. So the Marcus case is a very important case, in my opinion. Of course, it was conceded at trial, and that's in the first or second page of the transcript, that there is grounds for termination. And the Supreme Court has stated in that Marcus case, the most serious consequence of a finding that a parent has committed severe child abuse is that such a finding in and of itself constitutes a ground for termination of parental rights. So they never challenged that we had termination right to start with. The only issue really before the court was what was in the best interest of the child. And in that regard, it's very important to understand, and as I know you all do, that that question is to be judged from the perspective of the child. Now, that's not the parent. That child today is 5 years and 4 months old. He was taken right out of the NIC unit by the adoptive parents, and they have cared for him ever since. In fact, Mrs. Bolton is a stay-at-home mother. She takes care of all of this child's medical needs and getting him to his multiple medical appointments. Has done an excellent job of that. And the child has 4 siblings that live in that home. Well, I think the 20-year-old just moved out. But that child has a family now, and it would be an absolute travesty to take that child out of the only family he's ever had and put him into any place else. So I think we've carried the burden of proof in this termination case thoroughly. So do you have any questions?
Excuse me, I hear none. No, sir, no questions.
All right, thank you.
Hear from the appellant rebuttal.
I would point out one thing. During the circuit case, I did file to increase parenting time and visitation, which was denied. I also filed to keep the visitation in play during the appeal, which was also denied. So I did address those issues in the circuit court. Terry and I have done this for a long time, and I know him well. We're speaking about history versus the future. This case, the judge has tied this case to a history and has not examined accurately, we think, or thoroughly, the facts of the future. If we're not going to address rehabilitation and following the rules and getting your life right, then we don't need the rules. We need to stop this process before we get to a termination proceeding. I think Judge McAfee, and he's a friend to us all, Terry and myself, thoroughly talked about this case, but didn't thoroughly identify the issues accurately to support the findings. I think he spoke a lot. I don't think he particularly addressed those issues. I think he was very much swayed by the circumstances of the case, but not taking a hard look at the actual facts of what happened since the events in the history identified by Mr. Batista. He's talked about the age of this child. I'll be candid with the court. In the whole COVID time, this is the only case I tried. And we took us a year to get to that, and we sat in a courtroom 20 feet apart behind glass shields. That has elongated the natural flow of this case and made that age look more severe. But that isn't my client's fault. He didn't bring the pandemic on us. But like I say, that made this case go on, plus the appellate process. So I don't think the age thing is significant, plus the fact that a returned child takes that into consideration, and he addresses reunification not being a prime issue, focus now. That's not this case. That's a case in juvenile court. That case here is what happened on the preponderance of the evidence on these facts. I don't think reunification is a issue that's before this court. I think the focus of that would be, if this court sent this back or denied this, and you're back in juvenile court, I think the reunification issue then becomes an issue for that court. It's not an appellate issue. And I would argue that although that may be a change in focus, it's not a change in focus for this court. This court's dealing is what is the preponderance of the findings of the judge support this termination. And we think they have not supported it. We would ask the court to find accordingly. That raises more questions?
No questions. Court's thanks to counsel for both sides. We appreciate your arguments and your briefs in this case.